Hey, everybody, welcome to another edition of Legal Tech Week, the show where we talk about the week's top news in legal tech and legal innovation. It is May 29th, 2026. I'm Bob Ambrogi, and got some interesting stuff to talk about today, I think, so it should be a good show. And here to talk about it all are our regular panelists. Let's go around and do some introductions. Stephanie, you want to kick it off?
Sure. Sorry, as an alarm starts going off. Just kidding. Hi, I am
Telling
Stephanie.
you it's time to be on the show.
I know I was a couple minutes late. Sorry, everyone. I'm Stephanie Wilkins. I'm the director of content at Legal Tech Hub.
All right, and Victor.
Hi, everyone. My name is Victor Lee. I'm assistant managing editor for the ABA Journal, covering business of law and technology. You might hear my dog start barking at some points because, I don't know, she's talking to other dogs in the neighborhood. I don't know.
Gossiping. Dog gossip.
Talking about AI, probably.
All right. And Steve.
Hey, Steve Embry. I write the blog Tech Law Crossroads, and I also write for Above the Law.
And last but not least, Joe.
Hey everybody, I'm Joe Patrice from Above the Law, and I have a podcast called Thinking Like a Lawyer in addition to this one. And I'm here and ready to talk about some salacious things.
Yeah, legal tech is so
As
salacious. This week it is. This week we've got some salacious legal tech to talk about. That's great. I was worried that the chat wasn't working, but I see all of our Fireflies note takers are all arriving en masse. So I'm glad we are popular with the note taker set. Hopefully we have a few humans in the audience as well. So any humans out there, you can raise your hand and say hello. So we've got a juicy little story involving some AI driven sleuthing and goings on in the federal courts. It made me think back to, wasn't Above the Law originally called Underneath Their Robes, or was
That was David Latt's
David
original
Latt's
blog was named
original
that,
thing?
yeah.
And that kind of evolved. Did that?
And
I
he
don't,
went,
well, we don't have to
yeah,
go there. Never mind. Yeah.
yeah, we know. There were some stops along the way, but yeah,
Yes, but Underneath Their Robes was pertinent to some extent. But
yes.
coming up with the story. So Joe, and this is a,
Yeah.
this is a double header in a sense because Joe and Stephanie were both involved in this one. But I don't
Oh,
know, Joe, you want to kick it off or?
I kind
Yeah,
of
so
I kind of dust off my above the law hat for this too. Like we're
yeah,
no,
we
yeah.
Stephanie and I Woodward and Bernstein this. So we had a,
Deep throat
a
being an appropriate analogy.
yeah. No, yeah. So d down in the 11th Circuit, a committee did a investigation into a judge having received a complaint from a clerk. As part of this investigation, they determined this judge was having sex in their chambers, having an extramarital affair, sex in their chambers with a high-ranking police officer who had whose department had cases before the courthouse. Lots of there was a cushion a couch cushion in the office that got tested. There's in addition to all this, there are some allegations that the civil docket had been turned over to the clerks entirely, with the judge not even bothering to pay attention to it. And when all of these allegations started coming out, the judge lied to investigators about it for a while until eventually coming clean, so to speak. And then the 11th Circuit looked into this, determined uh, to say slap on the wrist is an insult to slaps on the wrist. The punishment was you never will get to be the chief judge of the district. So hooray, she can't do it. Well, I guess they didn't. Hold on, I'm getting ahead of myself.
They can.
Darn, you
They
gave it
can't
away.
do they can't do more administrative work. And they decided to keep the identity private and not get it out there. And the judicial conference, who then had to hear this afterwards, agreed with the 11th Circuit. And so the 11th Circuit successfully kept this quiet. Indeed, the judge was ordered to apologize to the clerks, but was specifically in the order given the latitude to write the apology vaguely so that no one could use the letters to prove that it was them who did this. So that's what's going on. how is this a legal tech story? Well, that isn't. What becomes a legal tech story is where Stephanie gets to come in, which is after writing about this insane decision to not publicly name somebody who committed acts that are probably impeachable. We started the process of trying to figure out who it was. There were a few details, even though they tried to anonymize it all over the place. There were a few details. The judge hires 2-year clerks, which is not common for district courts. There were a few other things. And I started trying to dig around in Oscar to see how many judges did that, whatever. In a side conversation that I have with Stephanie, Stephanie just said, oh, yeah, well, I just plugged it all into 2 different AIs, and I'll let you know what they come back with. And what they came back with probably, 10 minutes later or something like that, were a couple of reports, lengthy reports, like 20, 30 pages worth.
Oh, yeah.
Yeah, both coming to the exact same conclusion that it was Judge Eleanor Ross down in Atlanta. That has since been confirmed with Bloomberg Law talking to getting a human to go on record. We weren't going to publish this without a human because AI can hallucinate. But where this is a tech story is, Stephanie was right. The AI was able to scour these intentionally anonymized reports and methodically go through and say, well, there's this breadcrumb, there's this 2-year clerk thing. There's also the fact that the report talks about how they know a DA from their time at a state prosecutor's office. And it searched through all the judges and said the only judge who fits each of these facts that are kind of buried in these reports is this one.
Yeah. So basically what I did is I first fed the lengthy order or whatever it was in, and I said, tell me every identifying factor you can possibly tell me about the judge. And then it broke down all of the things that you could tell and could not tell. And then I said, well, great, run that against, like, do your deep research. I did Claude and I did ChatGPT in deep research mode. Run that against every possible judge it could be, because there were certain date ranges implicated by parts of it. That fact that the judge used to work at the former DA's office because there was a political event involved, and like all of this. And so literally within 10 minutes, Claude came back. Claude's was far more extensive than ChatGPT's, I will say, but they both came to the same conclusion. First, it came back with Eleanor Ross. There were a couple things that I was like, well, are you sure about that? Because it had conflated the political person with the cop and named that she was having an affair with this woman. And I'm like, well, are we sure about that? I was like, that woman's not a cop. So I actually, within 45 minutes, I got so much more. And that was iterating on this multiple times. And it had pulled out a thing that, in Florida, they don't call them district attorneys. They call them
state attorneys. That was a huge one.
Yeah. And I was like, well, just in case, pretend that's not a thing and run the Florida ones anyway to rule them out. Which it did. And it came with a maybe possible second choice, and here are the things that are off on it. But every single thing it had ticked off for Eleanor Ross was like the one political event she went to was off by 6 months of a date or something like that. And they even named who they think the police officer is and what the political event was. And I combined the 2 reports and dumped it into Google Doc to Joe, and it's like 30 pages of analysis. And that was, us just chatting over text, and it turned out to be totally right. And Joe can get into why this is, a big implication for maybe people aren't aware of exactly what AI can do. But it was just like, I love this kind of stuff. I love research. I was a PI for a year, and now I kind of feel like I should have a Claude-based PI business on the side. But yeah, it was like, I just did it because I'm a nerd and I thought that sounded fun. And yeah, it was spot on. It hedged itself as like, I can't guarantee this, but this is the highest likelihood. Here are all the reasons. And it was right.
Yeah. No, as Magnum AI there was explaining, I
thought I was Magnum AI. No, who was it?
Oh, that's right. You are.
Definitely the Magnum story. But yeah, no. So it goes through each of these points. It is super compelling. We know it's true now, but its reasoning was very compelling. And my takeaway that I talk about in the article is, you can tell that the judges really intended this to be quiet and never to see the light of day who this person was. And they included details because transparency requires them to have some they have to have some details to explain the disciplinary action, right? But that's too much. And what they thought, historically, what they would have thought was enough to keep this quiet is clearly not enough in the age of AI. And yes, a human probably could have worked this out over enough time, but it would have been a grueling effort and one that a lot of people probably would have given up on. We were able to do it Stephanie was able to do it in 20 minutes, or at worst. And it struck me, one, that judges are not prepared for what AI is capable of doing. They are hearing a lot about how it hallucinates cases. They are not hearing a lot about how it basically has destroyed the confidentiality that they want to have. Lawyers need to understand this happens because if you are trying to keep something confidential or trying to suss out something that's confidential in a due diligence set or something that you have, you probably need to understand that AI can do this because that will save you a lot of time long term. The scary implication, of course, is that anonymizing things is basically impossible. But putting that aside, just for the legal side of it, you better get on the fact that this can perform all of these tasks.
Well,
Yeah,
I mean, 'cause everything it did, sorry, one last point, everything it did, I could have manually or over the internet done somehow, but it looked at every potential judge and narrowed it down by criteria and then within dates. And then I even had it look at every potential high-ranking police officer in every level that were close enough in a certain distance to where the courthouse because they used to come by on their lunch breaks and have their little afternoon delight. And then and then like who had the clerks, and the clerks started reporting this from like 2000 or 2020 on, so it had to be somebody who was at a certain level of a judge from that point, and then who was a former DA, and so then would have attended a political event, and they actually found a record of the political event, which is pretty likely which one it was. And so it's like all things that you could have murder boarded out with the red yarn, but it did it in literally 20, 25 minutes.
As you were talking, Joe, I was thinking about state bar associations and their disciplinary proceedings because they often, enter an order applying, various penalties and discipline without identifying the lawyer. But I suspect that in most cases, there's enough there to figure it out or for AI to figure it out.
And we have a real issue here because some of those details, a prudent disciplinary system needs to identify, even if you're trying to keep things private, certain details of the behavior because, not being transparent about it would be worse. And so we're now going to enter a hard policy question of what level of transparency are we willing to trade to maintain anonymity if that's what you want to do, if you think that's a countervailing policy interest. Because if you try to be transparent without trading some of that off, it's not going to work.
And I would have to say too that AI rightfully gets slammed for bias and things all the time, but it did not do that here. I mean, I think we all, maybe not the same ones, but we all made certain assumptions about what genders the cop and the judge would be based on, who gets to be high-ranking cops and who gets to be high-ranking judges or whatever. But like it looked at every judge and every cop and every whatever and didn't account for which was which or whether they were even different genders or was it, what was the affair. And it just treated all of it as data points, which was great.
Yeah.
Yeah, I initially assumed it was the judge doling out the stiff sentence in this case. But...
No, it was the judge who declared all rise and...
It is. I mean, it is. It is scary. I think it was Horace pointed out, like if not to in any way minimize what you did, Stephanie, which is really clever, and I would never have thought to do that. But but
I'll take clever,
like,
but it wasn't special. Like you can
like
minimize it.
look at like what like this horse like what does Palantir know about us? I mean, what was that? There was like a saying at some point about like give me 3 pieces of information, like your email address, your something, and you know I can tell you your life story basically. And you know I've been kind of writing a bit about the whole Thomson Reuters stuff and what's going on with their support of, you know, they're providing data to ICE enforcement, and you know they keep saying, well, we're not providing surveillance data, we're just providing sort of personal data that's available out there in public records and whatever. But you take all this stuff together and you give it to you give it to an organization like ICE that also has relationships with Palantir and other sophisticated intelligence and surveillance and software providers. And it's just scary what they know about you. And it's not just, you know, it's not just bad people or criminals or something. It's all of us. They've got it on all of us.
Yeah.
Every red light we've ever run, they know.
Yeah. I was
Not that I've ever run a red light.
Yeah. Aside from now having said it was me and, you know, all the fireflies recording that, Joe just identified me as, you know, a former above the law columnist or whatever. I was curious to see if that would be like, who do you think that might be, and see if it could work its way back to potentially being me. But
good question.
But no, it was like
Probably
it was fun, and I mean I'm, you know, happy I thought of to immediately do it, but like it was zero. Like I was literally sitting on my couch and we were on a text chain with some other friends, and I was like, and like 15 minutes after I saw it, I was like, Claude thinks it's Eleanor Ross, and everyone's like, no, surely it's not her, whatever, blah blah blah. And I was like, nope, here's 30 pages on why it's Eleanor Ross.
That's a great point. You were on a text chain with another lawyer and 2 other legal reporters.
Yeah.
And all of us were speculating, and none of us had the idea of going to AI. All of us were playing around with like, well, what about this? What about that? And then you're like, I got it.
Well, that's because you're all such political wonks in your own way that I was like, I think I have a quicker way to do this.
I mean, we're old. You know, we're old enough that our first instinct was this is something that we got a murder board, to use Stephanie's term, and it isn't. And I think that's going to be the real hurdle for lawyer adoption. Is just even though intellectually I knew AI is capable of stuff kind of like this, at no point did it cross my mind to do it. Stephanie had to do it.
My mind. But did anyone else catch that Joe seems to imply that I was young?
Yeah, well, I mean, comparatively.
I think that's what he said.
Yeah.
You were a 2L when I was a 3L, so
I know.
you're really young.
Yeah. And I love a murder board more than all of you. Yeah.
It's also just the whole policy side here. That apart from the sleuthing and the identity, it's like why not reveal the identity? Why would the court have kept the identity secret in the first place? That's troubling to me. I mean, if a federal judge commits misconduct in his or her role as a federal judge, I think the public has a right to know about that. Why keep it secret?
I think
it just goes to the whole kind of like, I mean, federal judges, like, you know, I mean, I know Supreme Court justices, but like, you know, are different category, but they can pretty much define what counts as unethical and what counts as like, you know, conflicts of interest and whatnot. And I mean, any judge could always say, oh, well, and it did not compromise my ability to be a objective, you know, impartial judge, and here are the opinions where I followed the law and blah blah blah. You know, I mean, anybody can, you know, just like with this, anybody can use the data to try to you know, make their case. But I do wonder, sort of like, yeah, like if this, I mean, obviously we're still in the early stages. I mean, this is, you know, there's no, I mean, this, you know, this isn't a proof of concept thing yet. But like at some point, you know, other people are going to start doing this, other organizations are doing this and whatnot. And I do wonder, like, I mean, someone brought up sort of like the harm of it, but I also wonder then if like that'll cause, you know, people to then rethink sort of like, okay, well, how much information we even disclose about people? If we really want to keep it anonymous. I mean, like, you know, for a judge, you know, who may or may not have behaved unethically or whatnot. Okay, but what if we're talking about, like, you know, like a rape victim, or we're talking about like, you know, kids, you know, kids being trafficked or whatever, or stuff like that. You know, then things get a little things get much dicier, and you know, it does make me wonder sort of like if people will start to rethink sort of like how much stuff they should even disclose in the first place. But
Right.
I mean, but we're not there yet, obviously. But you know, but you never know how the technology is going to progress.
Yeah,
Yeah.
it could end up having sort of the opposite effect that, I mean, we want transparency, but it'll in fact make things less transparent. That's possible.
Yeah. I mean, it's the
Interesting
whole
point.
with great power comes great responsibility thing, right? Which like we did it and kept it amongst ourselves, and Joe wasn't going to publish it until somebody like other outlets had confirmed it. And he did nothing with the name of who we're pretty sure the police officer was, and I haven't seen that come up anywhere. Like it's not.
I've seen it come up other
Oh, have you
places, and
now?
other places have confirmed that it's exactly who our thing said. Yeah.
Okay.
So yeah.
Yeah.
Jeez, what an interesting concept. Power with
Yeah.
responsibility. Huh.
In some,
Yeah,
well,
right.
right, I actually, the fact that the AI came up with who the affair partner was, I actually thought was almost more crazy because
Yeah.
there's a lot less detail there.
Oh yeah. Well, yeah, and that's the one I had to push it. I didn't push it to get that name. It just originally conflated the political party candidate or the fundraiser candidate as who the affair was with. And I was like, well, I don't think your analysis is right because that person's not a police officer. And it was like, oh, you're correct. It's not. Let me correct that. And that's when it dove in itself into all the police officer research. I
Yeah.
didn't say, find me this name. It did it. But
That's
no, I
kind of
think that is the
that's
point
pretty
that,
interesting.
yeah.
Actually, that's
Yeah.
pretty interesting. It did it
Yeah.
on its own.
Yeah.
That's
Well,
kind of
Yeah.
scary too.
yeah, I was like that. And I didn't even say that. I was like, is she a police officer? And they're like, no, you're correct. Let me look through police officers. And then it was like, I looked through all these things. If you need me to go more broadly into like sheriff's departments or whatever, I'm like, no, I think we're good.
Yeah.
But yeah,
And the New York Post, the New
yeah.
York Post has reported the police
Oh, okay.
officer, and it is the same that we had too.
But I think with in particular, and this is from one order from the court too,
Yeah.
that it's based on. I think that's the big thing here. Like it's they put so much identifying information in that document, thinking they didn't. That is really the what I mean. If basically all they did was not give the gender in the name or the specific court, they gave so much date range, so much that like I'm confident, maybe not the police officer part, but I'm confident we would have gotten to all of this if we had wanted to put in manual work. Mine was just basically a test to see what Claude could do, and it A plus more than better than I expected.
Yeah. All right. Well, I was going to talk about kind of two stories this week that are kind of related on the same theme of attempt again trying to grapple with hallucinations and the use of artificial intelligence and different ways of trying to approach that. And one is a rule adopted this week by the Florida Supreme Court, which I thought I had in front of me here. Here I have it, which is basically attempting to tackle the hallucinations issue. And if Mark Palmer's in the audience, a big thanks to him because he was the one who alerted me to the fact that they passed this rule this week. But basically, they've amended the court rule to say that the signer of any document filed in any federal court must represent to the court that, quote, the legal authorities identified exist and are accurately cited. Pretty simple change to the rule. Lawyers were already required to sign court documents, and if you ever practice in federal court, we all know like Rule 11 that basically requires you to attest to that this is all based on good law and good facts and all of that. But this takes it a little bit farther and says basically you've got to attest that the citations are real and accurately cited. And it also extends it to self-represented litigants in the Florida courts. So they are also going to have to sign this attestation for anything they file. And one other thing the rule does is expressly authorize judges to impose sanctions on anybody who fails to for whom that representation proves not to be true and who does in fact file hallucinated or false citations. it's judges already had sort of an inherent authority to issue sanctions, but they explicitly say here that sanctions can include reprimand, contempt, striking of the document, dismissal of proceedings, costs, attorney's fees, or other sanctions. So that was one thing. That was Florida, and that's one attempt to try and regulate all this. And then the other one this was actually last week, but I don't think we talked about it, was the UC Berkeley School of Law had imposed this new student policy on the use of AI, which to me goes way too far in the wrong direction on this. They've put out this policy which basically forbids the use of AI for, quote, conceptualizing, outlining, drafting, revising, translating, or editing any work submitted for credit. It also bars students from uploading any course materials into generative AI systems and limits permitted research use to the narrow task of identifying sources such as cases, statutes, or secondary materials. All of this is done in the interest, they said, of preserving the teaching of thinking. The rule says thinking remains the sine qua non of good lawyering and of quality legal education. And this policy seeks to ensure that our courses focus on requisite cognitive skills by default. So to me, the Florida policy seems actually fine. Let's make lawyers sign that they've checked their citations. Others may disagree. I see Victor shaking his head. But the Berkeley one to me goes way off in the wrong direction to me. I think if law students aren't learning in law school how to use AI, then when they start representing clients, that's going to be too late.
I mean, just my thing with the Florida thing was that, like, I mean, applying it for pro se litigants too. It's like, well,
that's my objection.
What are they supposed to do? Like, I mean, and first of all, it's okay. I understand, like for lawyers, okay, you got to check everything, you got to make sure it exists and whatnot. But for pro se litigants, like, how are they going to know? And secondly, it's like, look, honestly, like in that case, I mean, even with, I know hallucinations and everything like that. Like, I mean, it's we've talked about a lot of this show, but like what court is going to be swayed by, like, if I'm a pro se litigant and I write out a brief and I cite this case like Smith versus Jones to be dispositive of my case, and a judge then goes, oh yeah, you're right. I mean, what, so like that's not going to happen. And so the idea that like a pro se litigant could cause a huge harm to the courts, I just don't buy it. But otherwise, I mean, I thought it was a fine. For lawyers, I thought it was a fine rule.
Yeah, I don't. It's not that I object to the rule. I just think it's more rules that really aren't necessary when there's already tools that do the same thing. But it doesn't hurt. But the pro se thing bothers me because the pro se litigants, they have a right to proceed pro se. That's clear. And if they have that right, then you obviously they're going to make mistakes. And it's not, it's one thing to say, okay, you can't cite a fictitious case, but then to say, but you have to make sure that you cite the case for the proposition that you cited for is accurate. That puts a real burden on pro se litigants because it's hard enough for us to do sometimes. And, I just see that part of it as a way to discourage pro se litigants and make it more difficult for them. I mean, they don't have access to the tools. They're almost always, underprivileged. They don't have resources. It's just like an access to justice kind of thing. So that part bothers me more than the fact that they're just adding a rule that doesn't really need to be there anyway. But so a lot of rules are like that.
Yeah. I don't know. On the pro se side, it doesn't bother me so much. I mean, I think it's going to at least, I understand it's going to be harder for them to understand, I guess, what's required of that. But I think my guess is that judges would just take that into account if it ever came to a request for sanctions and those kinds of things. I can't imagine judges are going to be all that tough on pro se litigants where there is some mistake. Yeah, all right.
I can. I mean, it's the underprivileged class, and you're gumming up my courtroom anyway, and get the hell out of here. That's kind of thing. I can. That's what I think is the danger of it.
Especially if you have a judge who doesn't even care about their civil docket, baby. But I'm just gonna jump in on the Berkeley thing for a second. I was really shocked by the Berkeley thing. It's
Ooh.
so,
Yeah.
so over the top. And in particular, so over the top and I mean, I don't want to sound like I have a prejudice here, but so over the top for San Francisco. I understand they hate Stanford, but like, guys, you can admit that AI exists without like giving in to the fact that Stanford has all this AI credibility behind it.
Also, like,
I mean,
talk
I
about
sort of understand what.
trying
I'm
to like
sorry. Go ahead.
making your students completely unprepared for the way the working world
Yeah.
works. Like, you can't touch it for like proofreading or brainstorming or anything. Like, come on.
And it's sort of like, prohibition. You really think they're not going to use it? I mean, really?
Right.
They're
How
going
would
to
they?
go
How
to the
would they?
speakeasy and turn it on. I mean, yeah, I understand what they're trying to do. I mean, they want to try to force students to think critically and not just blindly rely upon AI. That's well, maybe that's a worthwhile goal, but it's not going away. And I mean, they're going to use it anyway. So, I mean, it's also sort of a lazy school way out. Instead of thinking of ways, how can we teach with students that are going to use AI? They say, oh, just ban AI. Like, okay, you're going to be an accountant, so we're going to ban a calculator, so you
Yeah.
have to do it by hand. I mean,
Well,
come on.
okay, and I mean, well, I had a couple of. First of all, I don't know how they would even enforce this. Like, I mean, unless someone's gonna like volunteer that they used it, then what's
Well,
now
it's the
know what
code,
he's
it's
doing.
the student code of conduct, is my understanding.
Yeah,
That is
I
like what
mean,
is binding people. Yeah.
yeah, but looking at it sort of like on the extreme side. I mean, we talk about hallucinations and whatnot. Okay, look, if anything's going to make people like double check all the citations, to make sure that everything is kosher, on their writing on their legal research and writing samples or whatnot, or for or for whatever, then hey, maybe this is the way to go. I mean, like scaring them into possibly violating ethics rules for law school. Maybe that's the way to go. I don't know.
I mean, I
I
have
mean,
two
if you
cons oh.
go ahead, Joe, I'm sorry.
Uh, oh no, I was just gonna say I had two concerns where I think Berkeley might end up being right, and I like to think that the world is gonna evolve in a way where they aren't. But the two concerns I have where I think they may have a case, so I'll just throw them out as devil advocate. One is if these AI companies start actually charging us what we are actually consuming, and the price of AI becomes something of a prohibitive, the rich get richer and poor or don't have access, that could be a concern. And the other aspect that I think where they could be right, maybe, is there are these arguments that AI is increasingly homogenizing ideas because people don't fine tune it. Most people don't fine tune it the way they need to, and it, defaults to a mean, and the creativity starts defaulting to a mean, and that could be a problem if people aren't doing that. Now, that said, I think that the answer to that is you train people how to inject personality into it, but those are the two issues that I think could be problematic. And I'd like to think AI will be ahead of those two issues and that we'll resolve them before they become a problem. But I could see those two arguments, but that's the only
Yeah,
But even if you want to
it's
teach some kind of skills like that, why not make it just the first year and then
mhm,
Oh,
open
yeah.
it up beyond that? I
yeah.
mean, I think there's some legitimacy to saying for 1Ls we're going to restrict the use of AI in some of these tasks. But once you're past that year, then you need to start learning how to use this stuff in practice. Again, I kind of make the point in my write up on it is just that you don't want to walk out of law school and have these people start representing clients who've never used AI before. That's not doing them any service or their future firms or their future clients any service.
That's
Yeah.
exactly what I was
I
going
guess
to
so.
say. And it's like, sure, it's great, idealistic, whatever, and even the extra points Joe made. But the reality is that at the same time, you have these other law schools that are being really innovative and actively teaching AI as part of the curriculum. And if I'm sitting there hiring my next year or my next one associate, if I'm a small firm, or my next whatever, and I have somebody who I know was banned from touching AI for 3 years, or somebody who can show me all the classes they took and learned how to use it in legal work, I know who I want to pick. It's like it's doing the students a disservice.
Right. Well, and I wonder too if it, does the same prohibition apply to law school professors there? I mean, are they forbidden to
Well, I mean,
use these
They
tools
have to
as
grade on
well?
paper with red pen.
Well,
Right.
that's the thing. That's clearly what this is, right? The professors want to use it. The only way they could get away with it is if the
Yeah.
students aren't allowed to use it. That way the feedback loop doesn't catch them.
I wonder too what an impact it'll have on recruiting on students, whether the applications to go to that school will go down, or at least the applications of highly skilled students and how the kind of students you really want will decline. If I were applying for law school, that would be something I would take into account. I would say, wait a minute, you're not even you're not gonna help me learn how to use it. You're not even gonna let me use it. I'm not sure that that's the place I want to go, but
Yeah, meanwhile,
I
Stanford's
will.
partnering with Harvey, right? They've got some kind of a
Yeah.
deal with Harvey.
Well, of course they are.
Yeah.
Of course, Stanford's doing something like that. Stanford probably has money in it. I will say, and that's the thing with Berkeley. I don't think Berkeley's applications will go down because it's Berkeley. But if you're the kind of person who gets into Berkeley, you probably got into at least one of the other ones in that tier. And is it going to lead to somebody going, you know what, I'm fine with UCLA or something like that? I don't know.
Yeah, that's better said than the way I said it. That's the point I was trying to make.
Or it'll just force the students there to like get clever about how they cover, because look, they're not gonna just not use it, right? I mean, and it was, as I've said it before, it's like the definition of AI is so broad now. It could be anything. It could be like spell check on your Microsoft Word. It could
And
be,
isn't one of the things they specifically say is prohibited is using it for like proofreading and things? I was like, well, that's just baked into word processing. tools now.
Editing.
Yeah,
Editing.
Revising,
What-
translating, editing.
Yeah.
I did an article on this some time ago because there was an economist in, I want to say, NYU or someplace like that. He did some work on this, and his theory was it really is the professors taking the easy way out, because if they really wanted to force students to think critically, then they need to do exercises in the classroom where they have to think critically and can't work with AI because it's not there. And I was thinking when I wrote the article, when I was in law school, the Socratic method was pretty heavily applied. I mean, every class, that's the way it worked. And that is where that does help you. I mean, it scares the shit out of you, particularly when you're a 1L,
Yeah. Oh,
but
I
it does
hated it, but yeah.
but it does force you to think critically. But that requires more work on the part of the professor to apply that method and apply it correctly. And so, this guy's theory, and I can't remember his name, I can see if I can find the link, was that what's going on here is academia is essentially taking the easy way out. They don't want to work hard enough to get the students to do what they want them to do critically in different ways than they ever had before. They just want to say, okay, we're going to do things exactly like we've always done, and you can't use AI. That's it.
Yeah.
It's just not realistic from so many avenues in my mind. I feel like we're back 3 years ago when ChatGPT came out and high schools were like, no, we're going to ban it. And now we're up to law schools banning it. And I'm like, haven't we learned in 3 years that we can't ban it? It just physically doesn't work.
Yeah. I think
I put the link in the show notes, by the way.
Yeah.
Sorry.
I mean, I think I'm not an academic, but I certainly think that there are ways to effectively combine the teaching of AI and analytical skills in the same exercises, where you're maybe even like using AI produced briefs or something and asking students to critically analyze them and correct them and find out what's wrong or what's right about them and that sort of thing. I mean, I think that like the whole first half hour of today's show was an exercise in why learning these skills can be so critical. No, seriously, I mean, it was really clever, and that's something could if you don't have those skills, you're not going to be able to do. Well, all right. All right. Should we go to the WWE and and a little bit of spoliation going on here.
Well, see, I thought you were going to segue to WWE after the sex scandal. There is that aspect of it. So.
That would have been the right time, yeah.
Because it's a boring e-discovery dispute, but the details underneath it are much more salacious. So for those of us who watch professional wrestling, because we never grew up from being 6 years old. Then I'm one of them, so I don't judge. So what happens? Vince McMahon has been in charge of the WWE for a long time. He owned the WWE and whatnot. It was back when it was still WWF, and then they lost a trademark dispute with the World Wildlife Federation. So he had a misconduct and sex scandal where there were, like, he and some others were accused of doing some pretty awful things. And whatnot with women who worked in the WWE and whatnot. And so he got at the same time that was happening, he was also looking for a buyer for the WWE, and then ultimately they made a deal with the UFC's parent company, which seems like a perfect merger of fan bases and styles and whatnot. But what happened was, they got sued by some shareholders because supposedly they overlooked some other offers that might have been more lucrative, and so the theory of the case was that the reason why they did it was because Vince got assurances from the prospective buyers that they would indemnify him and they would protect him from his ongoing lawsuits, and they would give him a job as they'll keep him in charge of WWE for as long as he lived or until he decided to step down. And so, but he and some executives of WWE were using Signal to communicate, and they set their messages on auto delete and they would change the settings every few days based on conversations they had in volume and whatnot. And then, but even after they got hit with a demand from general counsel to preserve evidence, the messages were still being deleted. So basically, this is a spoliation issue. Like the judge the judge sanctioned them and gave the adverse inference against them, saying that certain facts will be presumed for the case going forward. So at the end of the day, this is an e-discovery. It's an e-discovery thing. It talks about auto deletion policies and things like that, and litigation holds and stuff like that. But underneath all of that, there's also like this salacious subtext to all of it. So again, don't delete your messages. Don't delete evidence. Follow GC, especially when they tell you to hold on to evidence in anticipation of litigation. Otherwise, you get hit with this inference. And now it's like I think they have there are a couple inferences that could be potentially harmful to them should the case go forward. Like I think one of them is that they're presumed that I gotta look it up, but they're presumed that they took the offer because of Vince's personal reasons and whatnot.
Can you smell what Vince is deleting? I don't know. I'm trying to come up with.
Well, I was hoping that his defense would be that someone, that it wasn't him, it was a masked man.
Triple H did it to him.
Yeah, well, Triple H was named in this thing too. So there's that.
I do not understand. My understanding of the world of wrestling ended when all of those characters were at their height, probably like late law school, baby. So it's been a while, but it is kind of crazy that the same people that I knew, the last crop of people I knew of, are all running the WWE now, which is weird.
Well, Triple H married Vince's
Stephanie,
daughter, so
right?
That was that's probably the biggest reason.
Good sanction stories, always good. All right. I think the only other story we have to talk about this week is Kirkland. I don't think anybody wrote about it, but the Kirkland announced that it's going to spend $500 million to build its own internal AI platform. Money well spent?
Yeah.
I guess if you
It's
got it.
interesting. The information had an article about this, like, does this signal that big law itself is the biggest threat to Harvey and Lagora? And I was like, seems like wild clod erasure, but okay. Maybe Kirkland can build its own thing, but not all the rest of the AmLaw 200 can. And also, from my perspective, it seems like Kirkland's just going down and repeating the same. If you think Harvey and Lagora are vulnerable, which that's a whole different discussion, if you think they're vulnerable at all, Kirkland's just entering itself as another player to get beaten because it seems to me as though the only threat to those models in a serious way is a foundational model coming and drinking their milkshake, as one would say.
I didn't understand why it would cost
the
500
thing-
million. Sorry.
That's what I was wondering.
Because
The thing I thought,
if someone was able to do like an open source version of Harvey,
Right. Mike
close code.
OSS.
So why wouldn't they just take that code and then just build on that, and that would be like, maybe add a few things, maybe change some of the graphics and whatnot. And there you go. Like how's that 500 million?
There's a bunch of them out there right now. There's a whole bunch of people like vibe coding these like imitations of Harvey and Lagora. And, I'm sure they're not straight line by line apples to apples imitations, but 500 million, it just seems like
that's a lot of money.
get
The
Clyde
500
Clearwater.
million, but you need the 500 million to pay McKinsey to create a slide deck to go, I think you should do this. What a brilliant idea. Hey, has anybody thought about the fact that the AI is functionally like we took McKinsey and made it real? It's just a thing that takes your dumb idea and goes, that's a brilliant idea. Did you realize you could make more money? We think you're very smart, which is all McKinsey has done for years as a business model.
Right. But the thing I
turned
wondered
it
about
in-
is, I was talking to somebody at Clock who was opining that some large corporations are going to do something very similar to this, and so that they can reduce the amount of time that the C-suite has to depend on in-house counsel, and in-house counsel has to depend on outside counsel. And so, if Kirkland can spend $500 million and pull this off, so could what? General Motors, Chase Morgan, you name it. So it's kind of an interesting situation. Oh, they're extra
Do we know any
quad.
detail? I mean, are they going to build it on one of the frontier models, or are they going to somehow try and build their own model? Or I haven't seen really any details about it. But
When you're spending that much money, you can do whatever you want, right?
yeah, I guess.
I don't know.
Maybe they're going to sell it, build it and sell it, and rake in millions of dollars like Harvey.
Hmm.
Yeah, I just like they could, and a question that was just an issue is just raised to me on the side was, what about confidential stuff? Like, does it protect them on that? And like, it's sort of like how I have a local small model on my computer for when I get embargoed stuff and I'm worried about putting it into an AI that is consumer facing. I just throw it into my little local one and see what it does. It seems like, yeah, you could probably do some stuff with confidential materials better that way, but that's not $500 million worth. That's running a mid-sized model on your intranet,
I
you
mean,
know?
Right.
my guess, just based on nothing, would be that they do plan to build their own model.
Yeah.
That kind of investment, but I obviously I do not know.
Yeah,
I'm
the
sure
really
considering all the
interesting
M&A
thing it
work that they
raises.
do and all the buyouts, all that stuff. I mean, they probably do have a lot of like confidential information that they're paranoid about. So if they can build a more like a more secure version of I guess Harvey, or not casting any aspersions, but like just like a more secure version of any of these commercially available models, and maybe that's more for their own peace of mind. But I don't know. I mean,
The real interesting thing about it, though, is that I mean, law firms, even large law firms, typically don't invest money like this to do things. I mean, they distribute money like this to partners at the end of the year. And so, it's kind of unusual that Kirkland could pull this off, because I'm got to be a lot of partners in the firm going, whoa, 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 wait a minute. You're going
I
to
feel
take
like Kirk,
$500 million of my money and do this? What?
I mean, I feel like in the like 12 billion or whatever they're sitting on, those partners are going to be fine. Like what is Kirkland this
Oh,
year?
yeah.
It's something like that.
But compared to our universe, those partners will be fine. Compared to their universe, what the fuck are you doing?
Yeah, 10.6 billion that they brought in. I feel like they're going to be just fine.
All right. All right. Anything else? Anything else we should talk about?
Yeah, well,
Yeah,
I
now
didn't
that
put an
Embry's dropped the
actual.
F-bomb, it's time to
Yeah.
quit.
Yeah.
I forgot to put anything in the log. I figured it was okay because, we talked about our experiment, but I would have put in this prompt injection story from Roll on Friday, the South America, where the lawyers actually literally put white text in a court document to their opposing counsel to try to trick them. I mean, like, I thought we were going to get prompt injection as a cybersecurity threat or hack or something at some point, but I was not. My money was not on lawyers using it in a court filing. Wild. Yeah.
So wild.
It's sort of clever.
I mean,
It is.
it's evil genius, but like, way to risk your law license. Yeah.
I guess, but yeah. Yeah, so Chuck had put it in the chat earlier also.
Oh,
Yeah. No, I'd seen it. I'd seen it last week because Roll on Friday. I don't understand their schedule over there. It's like they like publish a bunch of stories and then I don't see them for a month and then they're back or like whatever. But that one from last week, I always check them every Friday to see if they have new stuff. And that one, I just like jaw on floor. Like I can't believe
Yeah.
they tried that because again, I had heard about the threat happening in big discoveries as like a shady thing people are going to do in discovery for a while. I did not ever think you were going to try to defraud the court
No.
with it.
No.
Well, but I mean, in America, that would go over just fine because clearly the judges don't understand AI, so they're not using it enough.
Yep.
Maybe they just identified the judge in that long thing we saw
Ooh,
in white.
we've
ink.
all been misled.
Well, maybe that's the next thing. Is they take all the redacted files that you get and it's like, all right, figure out who's in the redactions.
Yeah.
Yeah.
I mean,
I'm sure Joe and Stephanie were on Signal all week, exchanging confidential communications about the identity of the judge. All right, well, I think that's it then. Unless we want to just hang out for another 5 minutes.
Whatever.
Nobody
Hey.
wanting to do that.
yeah.
Oh no,
If anyone needs any crimes solved, I might open a side.
I'll have to
Take,
go
take
one
all the
first,
old
then.
like Washington Post stories from Watergate and put them in and just see if they could have identified Deep Throat from any of the.
Ooh.
But I totally do
Yeah.
get now. I mean, not that I didn't get it before, but part of Everlaw for Good, one of the cohorts they offer it to is investigative journalists, and it always made sense. But until I did this, I didn't really have a real idea of like how awesome it could be. So yeah, I get it.
It was Deep Throat. Mark, what was his name? Mark
Mark Felt.
Mark Phelps. Yeah.
He got passed over for head of the FBI after Hoover died.
Right. He was
no
angel in his day, but
he probably wasn't. He probably didn't live up to the level of grand competence for an FBI director that we currently have. Like,
He didn't. You mean he didn't drink enough?
with Kash Patel.
He didn't have his own skull emblem.
I almost gave a very different answer when you said what was the actual name of Deep Throat. I'm like, oh no, the real person, not the movie.
Right. The Aziz Ansari impersonation of Kash Patel on SNL when they did the one about his own bourbon, which for those who don't know, he has his own branded version of bourbon. When they did that, and Patel basically and well, I'm sorry, playing Patel basically breaks the fourth wall. Is like, this is a real thing. This is an actual thing that is real. Is really the problem. SNL is starting to reach what we used to call the Onion effect, where like, this is not the Onion.
Yeah. Well, I mean, the U.S. news has kind of just reached the Onion effect in general.
Yeah.
Well, I think didn't they buy or they bought InfoWars, like Alex
Oh,
Jones?
that was so brilliant.
I'm just like, well, I'm not going to be able to tell which one is like.
Heidecker is doing a good job with that. Yeah.
I've been listening to this on a podcast called what's it called? It's all about Weather Underground, Mother Country Radicals or something like that. I think it's called, all about Bernadine Dorn and like the '60s Weather Underground, SDS, and all that. It's a great podcast. And there's a new book out too. But Mark Phelps is a prominent reminder in that book of just how sleazy the FBI long was, and the tactics, blatantly illegal tactics it would use to target those that it did not like. All right, well, off the legal tech angle, but we will. I think that's what does it for today, and we can be back next week and see what happens then. See you all then.
So long, everyone.
Have a good weekend, everyone.
Have a good weekend.